Okay, guys, so now that you have your company set up and you have your insurance in place, now it's time to turn to the A and CIA, and that is your agreements. So, your company, as we mentioned in prior videos, is set up to protect your personal assets. Your insurance is set up to protect your financial assets. And then agreements are in place to protect your business assets, like your reputation and your other assets. So, fun fact, did you know that contracts have been being entered into for over 4,000 years? And in fact, scholars believe that contracts is one of the main reasons why man began to learn to write, and that is how important they are. Now, I want to start by explaining to you how problems with agreements play out in court. So, as we discussed when we talked about insurance, there are two main types of ways that an entrepreneur such as yourself can get sued. There's a tort, which is when somebody gets hurt or property gets damaged. And then there is a breach of contract. And a breach of contract simply means that one side of the agreement didn't keep their end of the bargain. Now, the cool thing is you guys can sue for breach of contract if your clients or another party doesn't hold up their side of the deal. A good contract helps you get paid. Recently, there was a coach in Connecticut who was a divorce coach, and she sued a former client for breach of contract, alleging that the client failed to pay her for several years of fees under their agreement. Now, how she kept working with this client for several years without being paid is a whole nother training we probably should do, but the contract was clear on what the coach had to deliver. And the court said that she did deliver that. And so the client lost and had to pay her for all the years she paid her coach, which was several $100,000. So you see, agreements can help you get paid. On the other hand, your clients can also sue you if they feel like you didn't hold up your end of the deal. And this is what happened recently to a couple called Coral and Matt Grant. They had a company called The Secret to Life Coaching out of Windsor, Colorado. And I'm telling you that for a reason. So the Grants had a life coaching program, and they coached people, and then they trained people to become certified life coaches through their company. And after many years of running these programs, two of the Grants clients who lived in Texas decided after 8 years, did you hear me? 8 years, that they felt like they wasted their money, and they decided to sue the Grants for breach of contract. Now, the Grants contract agreed to pay the coaches a commission percentage or a fee when they recruited other coaching clients. But these two women claimed that they never got this money. So they felt like after 8 years that the Grants had not held up their end of the agreement. Now, what was especially bad for the Grants is that these two clients sued them in what's called a class action lawsuit. And what that means is these two women went around to a bunch of the Grants' other clients and got a bunch of these other clients to join them in the lawsuit. So the amount that the Grants were sued for, are you ready for this? I would suggest you sit down. It was $30 million. My friends, I can tell you right now, no one is going to give you $30 million worth of insurance for your coaching business. I mean, they might if it's making enough money, but most small business owners could never get that level of insurance. So this means that if they don't win this case, guys, they are going out of business. But the second bad thing is this class action lawsuit was brought against the Grants in the state of Texas. And that means that the Grants had to pay an attorney in Texas and travel back and forth to Texas for their case. Now, we don't know what the outcome of this case is, and it frankly might still be going on. But even if the Grants win the case, can you imagine how expensive it is going to be for them to defend it? And I sure hope they had good professional liability, errors and omissions insurance, because although it might not cover their $30 million claim, their insurance company still has a duty to defend them, meaning to hire them a lawyer and to help them fight this case on their behalf. We're going to talk more about what the Grants could have done differently to help them avoid this terrible situation. But first, I want to explain to you all of the ways and the financial and reputational damage that can be caused by a breach of contract claim against you. You could be forced to pay restitution, meaning you have to pay back all the money that you paid to your client. Compensatory damages, which means you are ordered to pay to your client any money that they may have lost due to your breach. So let's say they lost some business because they followed your advice, or they lost a client. You could have to pay that. There's what's called specific performance, where you could be ordered to follow through on the terms of the contract. And then there's punitive damages, and a punitive damages is just as it says, it's punitive. If you breach your contract and it's particularly outrageous, or the jury thinks what you've done is outrageous, or the judge, you may be required to pay these extra damages simply as punishment for what you've done. And as I've said in other videos, guys, remember that you may be 100% right on something and not even breach your contract with the person, but in front of a jury, if you are seen as more powerful, have more money, the stronger party, my friends, it just may not go well with you. So why am I telling you all this? Because we are no longer naked and unaware, my friends. We are the CIA. We are stopping these threats before they start with the final piece in our CIA system, your agreements. I'm telling you this because it is possible and actually quite simple to protect yourself from breach of contract claims and having to pay all these damages and experiencing what the grants have experienced. I'm guessing you want to know how. They could have saved their whole business and this whole mess with some very simple agreements. Now, listen, I know you entrepreneurs don't love paperwork or the legal mumbo jumbo, but guys, let's learn to love the fine print. I want you to say it with me. I love the fine print. So I'm going to give you my 3 top ways to offer incredibly strong protection against huge losses like the grants are facing in your business in a breach of contract or a tort claim against you. First, you have to have contracts in writing, guys. If you don't have a written agreement, it is much easier for there to be a dispute. And once a dispute arises, it really is just he said, she said. Plus, there are a lot of protections that agreement can provide you, which I'm going to talk about in just a little bit, and which street legal document templates offer to you. So first, you have to have a written agreement. Second, you have to have a good agreement. Guys, do not cut and paste and download a contract from the internet. Your contract should be specific to you and to what you do and to what you provide for your client. You need to read them or have someone who understands your business read them to be sure it reflects what you believe you are agreeing to. And then third, you got to make sure your agreements include protections for your company. At a minimum, you need to have a disclaimer or a disclosure. For example, in your group and one-on-one coaching contracts, we include a disclaimer that makes it clear and sets a right expectation right up front that the client is responsible for their own results, that the coach is not responsible for the results. You should have a limit on liability. Did you know you can limit how much you will owe in a lawsuit or dispute right in your contract? This is called a liability limitation clause. If you do have a liability limit written into your contract, whatever that amount is, it has to be reasonable. It can't be zero. Then this is the amount that the other party in the contract can obtain from you in a legal claim. So for example, in Street Legal God's coaching agreement, we limit the liability of the coach to the amount that the client paid the coach under the agreement. They can't get more than that. If you don't have a limitation of liability clause in your contract, you've exposed your business to liability of any amount. Now, of course, that limit won't apply if you do something intentionally wrong or egregious, but otherwise, these clauses can help you so much limit how much you'd owe in a legal claim or a lawsuit, and they can really help you avoid a lawsuit altogether. If the grants had had this in the contract, it's probable that they would not have been able to be sued for $30 million. You'll want to put a clause in place to protect your intellectual property. This means that your clients cannot run off with it and start their own business and use your property, intellectual property, as their own. an arbitration clause. And this requires, if there's a claim between the two parties in your agreement, it requires you to go to arbitration, which is private, and not court, which is public. Our contracts and street legal guide also require that any judgments be sealed, which again means they can't be made public. And this massively protects your reputation if something goes wrong. Again, if the grants had this in their contract, we might not know about this lawsuit and wouldn't be all over NBC News, and they might still have had enough reputation to start over. Number 5, you should have what's called a choice of forum clause. And all that means is you get to pick where you're sued if someone wants to sue you. So if the grants had this clause in their contract, they would not have been able to be sued in Texas. The cost to fight the lawsuit in another state is crazy expensive. The grants would have said the forum we choose is Colorado, and then that class action lawsuit would have had to have been brought against them in Colorado where they chose. And then lastly, you should have a class action restriction in your agreements. And this restricts the ability for your clients to bring a class action lawsuit against you. And this is huge, guys. If the grants had this in their contracts, the women would have had to sue them individually. And each lawsuit would have been limited to probably 6 or 7 figures at the max, if they would have brought a lawsuit at all. So a couple of notes. None of these powerhouse protections that I just explained are offered if you agree with someone verbally, which is why I can't stress to you enough to get your agreements in writing. I want you to say it again with me. I love fine print. And another friendly note, I want to remind all of you that all of your emails, your voice notes, your texts, and all your other correspondence between you and your clients and your vendors are discoverable and admissible in a lawsuit, which means they can become public. So remember that when you're dealing with your people. And then a final note. Did you know that your terms of use and your privacy policy on your website are a contract between you and the person using your website? Well, being that a lot of you have or will have online businesses and everybody has websites, these documents, these agreements are very important and provide you many of the protections we just discussed above with people who are using your website. And by the way, a privacy policy is required by law, so that's important. So guys, can't you see how important agreements are to stopping threats before they start? The fact is, none of us are perfect. And even if we were, it doesn't mean someone won't try to make a claim against us or try to get their money back from you. So coupled with your company protecting your personal assets, your insurance protecting your financial assets, and your agreements protecting your business assets and your reputation, guys, this CIA model is a 3-legged stool. It's that foundation that allows you to build strong and without fear. It is leveraging the power of this information to keep your money, your legacy, your family, and your business safe. Now, below, we have broken down the agreements into categories to help you understand what each category of agreement is for. We hope that helps.